I'm going to talk about the Supreme Court's decision 3.5 months ago in the Fisher case. The Fisher case does not mark the end of lawful consideration of race in affirmative action. It represents a reprieve. We don't know where we are moving. We will know more about where we're moving in 2014 when the other shoe drops and the Supreme Court decides the second of its two affirmative action and admissions cases, the Chouette case. And I want to talk about the Fisher case, what it leaves in place, what it changes in the law of affirmative action, what one university, namely my own university, is doing to adapt to and react to the Fisher case. And I'm going to say a few words about Chouette at the end. If you look at the table of contents on page 1 of this outline, let me just give you a hint as to where we're going. It's important for everybody to realize that the Fisher case does not change the basic jurisprudence of affirmative action. It adds a refinement. It's a very important refinement, and we will dig down deep to see what that refinement is. But analytically, the law of affirmative action remains what it was before the Fisher case was decided in June. So we're going to start by looking at the jurisprudential concept of strict scrutiny. It's important to understand the vocabulary of strict scrutiny as you envision the future of affirmative action on your own campuses. So we'll start analytically by going through the two-part strict scrutiny test. And then we'll talk about the Grutter decision, the 2003 University of Michigan Law School decision, which represented, in a sense, the moment of pellucid clarification as to what the law requires when an admissions committee takes race into account in making admission decisions. We will then look carefully at how Fisher changed the Grutter analysis. And you'll see in the outline, the pièce de résistance is a page in the middle of the outline that reproduces the critical paragraph in the Fisher case, highlighting a dozen imponderables that will shape every institution's approach to affirmative action going forward. I'm then going to talk about what we've done at the University of Delaware to react to some of the uncertainty created by the Fisher decision. The Fisher decision, as you will hear in detail later, requires institutions to consider race-neutral alternatives before deciding that a race-conscious affirmative action program can be continued. And the notion of race-neutral alternatives is one that sociologists, lawyers, and higher education administrators have grappled with on and off for 10 years. It now becomes an important consideration in upholding the use of race in an affirmative action plan. So I'm going to look very quickly at so-called race-neutral alternatives, not in an exhaustive way. That topic is worth a session in its own right, but just to highlight the kinds of race-neutral alternatives that we have all been considering since Fisher and will be considering in the future. And then I'll talk at the end about the Chouette decision, which is going to be argued in the Supreme Court tomorrow. It is an unavoidable fact in contemporary American higher education that without racial preferences, racial diversity would suffer at institutions that are selective in their admission processes. But preferences, at least for 50 years, have been recognized by reviewing courts as equitably and legally problematic. When we take race into account, we're engaging in an exercise that for at least 180 years in the nation's history was undertaken malevolently to use race as an excluding factor rather than as an including factor. The doctrine of strict scrutiny is a court-created jurisprudential approach to the analysis of racial preferences that essentially I would refer to as 2.5 strike analysis. Whenever an institution or a government agency takes race into account in according a benefit, in this case admission to an undergraduate program, it is engaging in an exercise that brings forth judicial skepticism. Courts are skeptical about the use of race. And they've fashioned the strict scrutiny test as a way of signaling to institutions that use race that they must do it with care, and they must do it in accordance with prescribed rules, because courts are skeptical about the use of race in any context. You'll see in the box on the bottom of page 2 the two prongs that constitute strict scrutiny analysis. Under strict scrutiny, a program that uses race as a determinant must be based on and must serve a compelling institutional interest, that's prong 1, compelling institutional interest, and it must be designed so that it is narrowly tailored to achieve that interest without fallout with respect to people who can't take advantage of the program. That's the so-called narrow tailoring prong. The compelling institutional interest prong looks at why an institution takes race into account. The narrow tailoring prong looks at how race is taken into account. So let's talk about the compelling institutional interest test, or prong, of strict scrutiny. In 25 or 30 years of litigation, institutions and government agencies have offered to the courts literally scores of interests that are served by taking race into account, and sought to persuade courts that those interests are sufficiently compelling to satisfy the first prong of strict scrutiny. My own personal favorite was a court in the South 25, 30 years ago that offered as its compelling rationale for taking race into account the fact that it had been ordered by the U.S. the U.S. Education Department's Office for Civil Rights in a consent decree to take race into account. That seemed pretty compelling to me. It was required to do so by a federal agency that enforces the civil rights laws. That seemed pretty compelling to me. But that wasn't deemed to be sufficiently compelling to satisfy the first prong of strict scrutiny. To collapse several decades of jurisprudence into a simple rule, there's really only one interest that courts have consistently viewed as being sufficiently compelling to satisfy the first prong of strict scrutiny, and that interest is fostering diversity in the student body. Diversity is considered to be a compelling rationale for race-based affirmative action in admission, sufficiently compelling to satisfy the first prong of strict scrutiny. I'm going to diverge here for a moment by telling you about the Hopwood decision in 1996. In the early 1990s, a challenge was mounted to the race-conscious affirmative action program operated by the admissions office at the University of Texas Law School. And the Fifth Circuit Court of Appeals, the court right below the Supreme Court, stunned legal commentators the nation over by ruling that because of the passage of time and because of some emerging, evolving social mores, diversity was no longer sufficiently compelling to satisfy the first prong of strict scrutiny. And when the Fifth Circuit made that ruling in the mid-1990s, it dumbfounded legal commentators because without diversity as a rationale sufficiently compelling to satisfy the first prong of the strict scrutiny test, there was no way to satisfy the first prong. And the effect of the Hopwood decision was to kill race-conscious affirmative action in the states that were part of that federal circuit, Texas and other states in the South. So from 1996 until 2003, it was unlawful in Texas to operate a race-conscious affirmative action program for the simple reason that the rationale that the University of Texas offered, namely fostering diversity in the student body, wasn't deemed to be sufficiently compelling by the Fifth Circuit to satisfy the first prong of strict scrutiny. And to jump forward, first in 2003 when the Supreme Court teed up the two University of Michigan cases, and then in 2013 when the Supreme Court teed up the Fisher case, we lived in fear that there would be a majority of justices on the Supreme Court that would rule that the diversity rationale wasn't sufficiently compelling to satisfy the first prong of strict scrutiny. This is a long-winded way of saying that in a sense, affirmative action up until the Fisher decision was hanging by a thread, so to speak, because without diversity as the way of satisfying the first prong of strict scrutiny, there was no way to satisfy the first prong and no way to offer a race-conscious affirmative action program that would satisfy strict scrutiny. So I'll take a deep breath and say it again. The only way to satisfy the first prong of strict scrutiny analysis is to predicate an affirmative action program on its contribution to fostering diversity in the student body. Institutional documents have to recite that the institution is committed to diversity in its fullest sense, that it's an important, indeed compelling, institutional mission to serve, to foster diversity. By doing that, by including diversity-conscious, diversity-endorsing language in institutional governing documents and in other institutional policies, an institution satisfies the first prong of strict scrutiny. In 2003, when the University of Michigan cases teed up once again the issue of whether diversity was sufficiently compelling to satisfy the first prong of strict scrutiny, Justice O'Connor, writing for a majority of the court in the law school case, Grutter, you'll see the language toward the top of page 4, made a pretty simple declaration. Justice O'Connor wrote, "Student body diversity is a compelling state interest that can justify the use of race in university admissions." The state of the law is pretty clear, and it remains clear after Fisher, that a race-conscious admission program satisfies the first prong of strict scrutiny if it's based on an institutional commitment to fostering student body diversity. The action isn't with prong 1, it's with prong 2, the so-called narrow tailoring prong, which is discussed starting on page 5 of this outline. If the rationale for using race as a decisional criterion in an admissions program is sufficiently compelling, i.e. keyed to the institution's interest in fostering student body diversity, then the program, the admissions program that uses race as a determinant, must be designed in such a way that it is narrowly tailored to be implemented as narrowly as possible. The first prong of strict scrutiny, compelling institutional rationale, is lofty. It's pedagogical. It involves statements like the ones you'll see on page 3 and 4 of the outline, declaring the pedagogical importance of educating students in a diverse environment. It's, to use the word again, lofty. Narrow tailoring analysis is down and dirty and in the gears. It involves the manner in which the affirmative action program actually operates. And it reduces to a series of relatively straightforward do's and don'ts about the design of the affirmative action program. These are so simplistic as to almost generate titters, but they're absolutely immutable do's and don'ts, the failure to comport with which will doom your affirmative action program on the ground that it isn't narrowly tailored. So number 1, an affirmative action program in admission cannot use the language of quotas. In the 1960s and 70s, when affirmative action was a new concept, distinguished American universities fostered affirmative action by setting up quota programs. The first case that reached the Supreme Court was a case involving admission to the medical school at the University of Washington, in which the medical school just reserved a certain number of seats for minority students. It was a quota pure and simple, and the Supreme Court has never accepted the notion that quotas satisfy narrow tailoring. Number 2, the program has to recite down in the gears that it will be periodically reviewed and that it will sunset after a certain number of years. How many years? Doesn't say, 5 or 6 maybe. So if you're designing an affirmative action program, if your task is to take a computer screen and a keyboard and draft a program that takes race into account in making admission decisions, that program has to recite on its face that it's for a set number of years it will sunset automatically, and it will be reviewed prior to sunset to determine whether the need for race-based affirmative action is still compelling. Number 3, in the implementational details of the affirmative action plan, every folder has to be assessed against all folders. And that means that any, if you'll allow me to use this phrase, admissions shortcut that allows minority applications to be judged in isolation is going to violate narrow tailoring. Again, in the 60s and 70s, it was pretty common for institutions of higher education to have minority subcommittees that would look at minority applications, one candidate assessed against the others. It was also a common practice to have differentiated academic indices or objective cutoff scores, so that if your SAT score and your grade point average manipulated using some logarithm equaled X, you would have a number that was different from X for racial minorities. It was a differential standard. Anything that could be viewed by a reviewing court as a way of batching minority applications or considering minority applications as a subpool or assessing minority applications in accordance with a differentiated standard ran afoul of narrow tailoring. So again, if I can summarize before moving on to Grutter. To withstand legal scrutiny, if you are using race as a factor in making admissions decisions, you have to have a compelling reason for doing it, a compelling institutional interest served by doing it. And the only interest that is safely compelling enough is fostering student body diversity. And you have to design your program so that it is narrowly tailored to serve the purpose of diversity without having ancillary implications. And what that means is it has to be designed in a way that satisfies the do's and don'ts that have developed over 15 or 20 years of litigation over what narrow tailoring requires. The important takeaway, and the one thing that everybody in this room must remember, is that before Grutter, as a result of Grutter, before Fisher, and after Fisher, it is lawful to take race into account. It is lawful to take race into account. That has been true arguably since the mid-1970s. It has been true in spades since 2003, when Justice O'Connor made that simple, short, declarative sentence establishing that as the law of the land. And nothing has changed with respect to strict scrutiny analysis after Fisher. So take a look now at Grutter, starting on page 6 of the outline. Grutter was one of a tandem of cases, two cases that made their way to the Supreme Court in the 2001, 2002, 2003 timeframe. Grutter involved the validity of an affirmative action program operated by the University of Michigan Law School, which overtly took race into account in a way that was designed to foster student body diversity for very compelling reasons that were developed at length in the record, and in a fashion that was narrowly tailored, not to violate any of the do's and don'ts that are part of the narrow tailoring request. One of the things I will ask you to look at without reciting it for you is the description on pages 6 and 7 of the admissions program operated by the University of Michigan Law School. It was complicated. And in a couple of pages, we'll see a brief description of the admissions program operated by the undergraduate admissions office at the University of Texas, the one that was challenged in Fisher. It was complicated. One reason it was complicated was because the narrow tailoring requirements that are part of strict scrutiny analysis impose a burden on a college that's using race, that's taking race into account, to develop the program in a way that clearly manifests the commitment to narrow tailoring. And it's tough. Intuitively, there are easier ways to achieve racial diversity than the complicated way that the University of Michigan did it, that you'll see described on pages 6 and 7. And I won't reiterate that policy, other than to say that the University of Michigan holistically, a popular word in admissions offices, holistically looked at every applicant to the class against every other applicant. There were no batching, there were no cutoff score separations, and so forth. Now, if I can allow politics to intrude for a moment, the Grutter decision resulted in a 5-4 Supreme Court decision in favor of the affirmative action plan operated by the law school at the University of Michigan. And take a look at that lineup of justices. Justice Sandra Day O'Connor wrote the decision for the majority. She's not on the Supreme Court anymore. She has been replaced by an avowed opponent of affirmative action named Sam Alito. Justice John Paul Stevens and Justice David Souter are both retired from the Supreme Court. In Justice Souter's case, he was replaced by Justice Sonia Sotomayor, who is, I'm grossly oversimplifying here, but is essentially sympathetic to the goals of affirmative action. And Justice Stevens was replaced by Elena Kagan, who has been unable to participate in either the Fisher case in 2013 or the upcoming Chouette case, because prior to her elevation to the court, she was a Justice Department official who was involved, who took positions on those cases. So there were 5 justices in the majority in a very closely divided case in 2003, only 2 of whom are still on the court today. And there were 4 justices who voted against the affirmative action program in the Grutter case. One of them was Justice Anthony Kennedy, who's the critical swing vote on virtually every case decided by the Supreme Court these days. So the 2003 Grutter decision, which was announced while the nation's higher education lawyers were at their annual conference and brought that conference to a complete standstill, represented a reprieve for affirmative action. It represented, by a vote of 5-4, an endorsement of the principle that had been adopted in the 1970s, but not by a majority of Supreme Court justices, that strict scrutiny applies to the use of race in college and university admissions, challenges to college and university admissions programs, that diversity satisfies prong 1 of strict scrutiny, and that narrow tailoring requires certain do's and don'ts to be observed with respect to prong 2. It's worth lingering on page 8 of the outline on the reasons Justice O'Connor gave for the compelling quality of fostering student body diversity. Justice O'Connor really pointed to 2 separate thoughts as to why it is important for undergraduate students to be, or law school students, to be educated in a classroom that is diverse holistically. One was a reason internal to the higher education community, and one was a reason external to higher education. Internally, Justice O'Connor observed that learning is at its best and most robust inside a classroom when students of differing views and differing backgrounds collide with one another and challenge one another's assumptions. And I know that intuitively makes sense to me. To educate students in a classroom where everybody comes from the same background and shares the same political, social, and other tenets is to deny students the full glory of what it is to go away to college and learn by being challenged. So that was one thing that Justice O'Connor pointed to as a reason why diversity is compelling. The other thing she alluded to was the fact that we live in a diverse world. We are preparing our students for jobs where it will be important for them to be able to communicate and interact with people who come from a variety of racial and other kinds of diverse backgrounds. There was a powerful brief submitted in the Grutter case by generals in the military services who said, we couldn't train officers to be effective Army officers if they weren't trained in an environment where they were bruising with one another during the training period. Just to throw an officer into a country somewhere where that officer is unable to cope with racial and ethnic diversity doesn't serve the United States well. So the other thread in Justice O'Connor's opinion was this notion that we educate students in a diverse environment because the environment in which they will work is diverse, and it's important as part of their ability to contribute as American citizens to prepare them for the diversity of the society they're going to be living in. Justice O'Connor, in her discussion of narrow tailoring, added two new threads that didn't change the analysis very much, but which caused legal commentators to scratch their heads and wonder what the implications were. Thread number one, you'll see alluded to on page 9, was a discussion of a concept that was brand new to the law of affirmative action in 2003, the concept of critical mass. Justice O'Connor hastily, I would say, in a couple of paragraphs, laid down some thoughts on the importance to the education that students receive, minority students receive, to having a critical mass of students. There's a very, very nice quotation in the opinion that some attention to numbers, that the law schools, where am I? You know what, I took it out of the, oh, no, here it is. Nope, it's not in this, I edited it out. But she had a nice passage in which she said, without a critical mass, law school students, in the case of Grutter, were being set up for failure because even if they were admitted, they didn't have a support network that was strong enough to allow them to succeed. I won't go into a lot of history here, but I mentioned earlier the Hopwood decision from the mid-1990s. Stanford University Law School Dean Paul Brest was, to my knowledge, the first person who ever alluded in court testimony in an affirmative action case to the importance of critical mass. In a deposition in the Hopwood case, he was asked, why is it important to admit, a certain number of minorities? Why isn't one enough? It wasn't put quite like that, but and Dean Brest said, because it's really important, this notion of critical mass is built into academic success. It's true for racial minorities, it's true for all sorts of people. It was true for women a generation ago. You couldn't just admit some, you had to admit a critical mass. It wasn't terribly scholarly, it wasn't weighted with footnotes to the literature. In 2003, Justice O'Connor, in a couple of paragraphs, suggested that it was perfectly appropriate for the law school in making admissions decisions to ensure that it was admitting a critical mass without defining what that number was or how it was determined. And then she spent another paragraph backtracking, explaining why it was consistent with the Supreme Court's anathematic opposition to quotas, nevertheless to allow numbers consciousness in the context of affirmative action, in the context of critical mass. But the point that I wanted to make was, I hope you'll allow me to inject just a little of my own belief here. It is really hard to imagine a critical mass analysis that doesn't shade over very dangerously close to a quota analysis. And in 2003, Justice O'Connor alluded to critical mass. It's 10 years later, and the notion hasn't been enriched in a lot of lower court decisions. I think a lot of people are afraid to go there for fear that any discussion of the importance of admitting a critical mass of minority students will sound like quota language and will be met by conservative judges more conservative than the 5 who voted with Justice O'Connor, won't buy that at all. So you'll see in that indented paragraph on page 9 some of the backtracking that Justice O'Connor did, and the final rule that she enunciated. I'm going to read it slowly. It's at the end of that indented paragraph. Some attention to numbers without more, don't know what that phrase means, does not transform a flexible admissions system into a rigid quota. So this was the first strain that Justice O'Connor introduced into affirmative action analysis in Grutter in 2003. And it was a strain that posed no fear in the minds of affirmative action proponents. It was an interesting thought, but it wasn't a thought that necessarily slowed progress toward the adoption and defense of race-based affirmative action programs. The second thread is the one that you see illuminated on page 10, a very peculiar passage in Justice O'Connor's decision. Very unjudicial. It doesn't sound like a judge making this enunciation. I almost sounded sort of like an impatient social scientist. And she said, programs have to sunset. That's been a feature of narrow tailoring analysis for a long time. But, said Justice O'Connor, at some point they can't be continued. At some point, enough is enough. And the rationale for conducting a review and then renewing an affirmative action program for another 5 years or 10 years will lose its impact. And Justice O'Connor just plucked a number out of the air, 25 years. And she said, we expect that 25 years from now, 25 years from 2003, the use of racial preferences will no longer be necessary to further the interest approved today. And I remember distinctly after 2003, after the decision was announced in 2003, meeting with college and university attorneys all over the country and saying, well, what are we supposed to do with that? I guess nothing for 24 years. But at the end of 24 years, is a whistle going to blow? It's going to be sort of, the end of the game. And at that point, you can't take race into account under any circumstances. We will never know what goes on in the confidential deliberations of the Supreme Court. But I've heard legal commentators speculate that the 25-year reference bought a vote and got to 5 for the legal principles that Justice O'Connor was enunciating in Grutter. It remains just an inexplicable part of affirmative action jurisprudence, one that the next generation of college and university administrators are going to have to come to terms with. Okay, in Fisher, decided in 2013. Again, on pages 10 and 11, I have described the admissions program operated by the undergraduate admissions office at the University of Texas. And just in a very brief, broad brushstroke, in 1996, the Hopwood decision had eliminated the lawful use of race as a criterion in admission in Texas. And the University of Texas had adopted a so-called race-neutral alternative known as the Texas 10% law, which basically allowed Texas to admit the top 10% of every graduating class from a Texas high school, the somewhat hypocritical theory being that many of the high schools in Texas had student bodies that reflected patterns of racial segregation. And if you took 10% of an all-black high school or an all-Hispanic high school, there was your minority admit portion of the class. So from 1996 until 2003, Texas did not use race. It relied entirely on this so-called race-neutral alternative. In 2003, when Grutter was decided, and the Fifth Circuit decision in Hopwood was essentially overruled by Grutter, decided by the Supreme Court, the University of Texas went back to the modified use of race as an admission criterion, but in a complicated way that's described, if you can understand it, on the top of page 11. Essentially, they admitted 60%, 60 to 80% of their class using the so-called race-neutral alternative of the Texas 10% law. And they filled the rest of their class by calculating an academic index and a personal achievement index, which considered holistic factors, one of which was race. And the University of Texas admissions plan was lauded as the challenge, as the Fisher challenge made its way up through the lower courts, by the federal trial court, who said it would be hard for UT to have constructed an admissions policy that was tailored more precisely to the requirements of Grutter. It was based on the institution's commitment to diversity, and it reflected every single one of the narrow tailoring do's and don'ts to a T. In 2013, at the end of June, the Supreme Court, by a surprisingly strong majority of 7-1, issued a decision that I would call, I don't know how to describe it, a holding pattern decision. The court did not declare the admissions policy unlawful, and that double negative is deliberate. It did not declare the admissions policy lawful. but it did not declare it unlawful. It formulated a refined, narrow tailoring requirement that I'll describe in a minute, and it sent the case back to the lower courts in Texas to determine whether that refined requirement would result in a ruling upholding or striking down the use of race in the admissions office in Texas, at the University of Texas. And again, if you look at the bottom of page 11, you will see Justice Kennedy, who dissented in Grutter, writing the majority opinion. Two of the justices who dissented in Grutter along with Justice Kennedy, Justices Scalia and Thomas, joining the majority opinion. And only Justice Ginsburg dissenting on the ground that the University of Texas plan should have been upheld as lawful, rather than remanding the case to the lower courts. There was a substantive ruling of very considerable significance in Fisher, and you see it reproduced at the top of page 12. Diversity is still legally a compelling rationale sufficiently strong to satisfy the first prong of strict scrutiny. So that bullet is dodged for the time being. And again, if I can say this, if the Supreme Court were ever to hold that diversity is not compelling enough to satisfy the first prong of strict scrutiny because of the absence of any other compelling rationale, race-based affirmative action would end. So that bullet's dodged. But with respect to narrow tailoring, the Supreme Court added what I consider to be a kind of ominous new requirement. And if you look at page 13, we're going to really dig down and look at what the Supreme Court did in the pivotal paragraph. Okay? And I'm going to read just very slowly as we go along, highlighting these rhetorical questions in the margin. People attend sessions like this because they want answers. And I have to say, I can't give you answers to this absolutely mystifying set of propositions that the Supreme Court embedded in the Fisher decision. I will tell you, after we go through Fisher, what the University of Delaware is doing in response to this language. But everything that I'm about to say takes place against the backdrop of an expression of real judicial hostility to the continued use of race. And so what a reviewing court would do to what we're doing at the University of Delaware, or what a reviewing court would do to what you do on your own campuses in an effort to preserve the legality of consideration of race in your admissions program, I just can't predict at this point, and we won't know for several years until court decisions give substance to some of these balloons on page 13. So, starting in the first paragraph, once the university established that its goal of diversity is consistent with strict scrutiny, there must still be a consideration of narrow tailoring. The university must prove that the means chosen to attain diversity are narrowly tailored to that goal. On this point, the university receives no deference. Just keep that line in mind. The university receives no deference. If you set up a committee to examine whether race-neutral alternatives suffice to get you to your goal, you're making what I would think are quintessentially academic judgments, the kind to which courts in past years have given considerable deference. No longer. Next paragraph. Narrow tailoring requires that the reviewing court verify that it is necessary for a university to use race. This involves a careful judicial inquiry. Judicial, I circled that word. You'd think it would require a careful academic inquiry, but it requires a careful judicial inquiry into whether a university could achieve sufficient, question mark, diversity without using racial classifications. Just pause about that word sufficient. I'm going to come in a couple of pages to the very difficult calculus you have to do in determining whether a race-neutral alternative suffices for purposes of getting you to your diversity goal. Although narrow tailoring does not require exhaustion of every conceivable race-neutral alternative, I suppose that's good news. You don't have to go through a long laundry list of race-neutral alternatives. Strict scrutiny does require a court, again, the focus is on the burden on the reviewing court, to examine with care and not defer to. And now comes this magic phrase, you tell me what it means. A university's serious, good faith, consideration, that's an important word, consideration, of workable, a word that's repeated 3 times in that paragraph, race-neutral alternatives. So our task is to consider. The president of the university looks at you and says, how do you consider? What does that mean? Does that mean hiring an expert? Does it mean setting up a committee? You have to consider race-neutral alternatives, but only those that are deemed workable. Consideration by the university is, of course, necessary, but it is not sufficient to satisfy strict scrutiny. The 3rd time in this paragraph, the court has warned that the judgment is ultimately not an academic judgment, it will be a judicial judgment. The reviewing court must ultimately be satisfied that no workable, there's the second use of that word, race-neutral alternatives would produce the educational benefits of diversity. If a non-racial approach could promote the substantial interest about as well, and I'm going to stop there and say, when I saw that phrase, about as well, I circled it and put in the margin, you'll see it in this margin, come on. How are we as academicians supposed to determine whether something satisfies the substantial interest about as well? That's as loose a term as I've ever seen in a Supreme Court decision. And at tolerable administrative expense, the first introduction into this paragraph of the notion that in determining whether a race-neutral alternative is workable, we are allowed to consider whether the administrative expense it imposes is tolerable. But again, tolerable, what a word. I have no idea what criteria we're supposed to use, how we're supposed to make that judgment. Then the university may not consider race. Can I read that again? The reviewing court must be satisfied that no workable race-neutral alternatives would produce the educational benefits of diversity. If a non-racial approach could promote diversity about as well and at tolerable administrative expense, then you can't take race into account. Narrow tailoring prohibits you from doing so. And then that last sentence, strict scrutiny imposes on the university the ultimate burden of demonstrating. I want you to put an underline next to that word, demonstrating, before turning to racial classifications, that available, workable, 3rd time, race-neutral alternatives do not suffice. That sentence just makes me cringe. We have to demonstrate. I have no idea what that word means. Demonstrate. Do we demonstrate it by, for example, just looking at the history of the University of Texas, which from 1996 to 2003 was not allowed to use race into account and suffered an egregious reduction in the number of minority students that enrolled there? And then, when it used race in 2003 to 2013, the number of minority enrolled students increased? Is that a demonstration? Does that suffice? I don't know. To me, as a lawyer, trained in the lawyer's craft, when I see the word demonstrate, I think to myself, that means evidence. We have to have evidence. We have to generate evidence. Whether it will be compelling evidence in the minds of a reviewing court, we'll leave for another day, but the burden that the word demonstrate imposes, as far as I'm concerned, means we have to have evidence. If the question is, how did you determine that this race-neutral alternative didn't suffice? The answer is, well, we looked at this evidence. And I'll get in a minute to how we're construing that term at the University of Delaware. So, biggest headache of all is the use of that word demonstrate. I have no idea what we're supposed to do to make that demonstration. Second biggest headache of all is the verb at the end of that sentence, suffice. We have to demonstrate that the race-neutral alternative that we're analyzing doesn't suffice to get us to our diversity goal, without any suggestion of what we're using to measure the sufficiency of what we achieved by doing that or not. So next page, this summary on the next page is what's new in Fisher. This is what Fisher adds to affirmative action jurisprudence as it evolved through Bakke and Grutter. And let's just look at this. I will read the word and you can look at the right-hand column and see the ambiguity of the word that the Supreme Court uses. You're allowed to take race into account and you can continue to do so, but you must demonstrate, whatever standard that imposes, by considering some but not necessarily every conceivable race-neutral alternative. And you have to do that in a serious, good faith manner. I'm not sure, frankly, what the difference is between serious and good faith. Whether each race-neutral alternative is available, workable, involving nothing more than tolerable administrative expense. Each one of these is an adjective without any meaning, any content, any way of gauging what will be sufficient in the minds of a reviewing court. And suffices, whatever that means, to satisfy the institution's commitment to diversity about as well as explicit reliance on race, and all of that without expecting that your judgments are going to be subject to any kind of deference if your affirmative action program is challenged and you find yourself in court defending what you've done. To me, the frightening part of the text on page 13 is the repeated emphasis to what the court will do, what burden of reviewing deference a court will give, with literally no reference to the difficult academic judgments that will underlie whatever demonstration you're making that a race-neutral alternative doesn't suffice. So here's what we're doing at the University of Delaware. This decision came down at the end of June, just as our admissions cycle was beginning for 2013-2014. And let me say this, I know that I'm being taped and what I'm saying will be available for citizens of the world for all posterity, but I will say this, we invented this on the fly. We did this in order to demonstrate that we were doing the analysis required under Fisher. I have no idea whether this is right or wrong. We didn't have the benefit of any kind of discussion with other universities as to what they're doing. I'm hoping, if I finish this in time, that somebody will raise her hand or his hand and say, well, at our university we're doing it differently. This approach at the University of Delaware was born out of two imperatives. Number one, I felt it was important to generate evidence. Very simple proposition. And number two, I felt it was important to do this before the first admissions file was reviewed in 2013, 2014. I didn't want to admit a class and have an Abigail Fisher in that class who argued that she was admitted or denied admission on grounds that offended the Fisher decision. So I wanted to do it in 2.5 months, inventing it as we went along, with the object of having at the end of the exercise a cardboard box, I'm a very visual person, with folders, one folder for each race-neutral alternative, that contained evidence that we had looked at it. Okay? So this is what we did. We formed a committee. How can you ever tackle an important higher education issue without forming a committee? We designated the logical people to serve on that committee. We are blessed in having faculty members who are experts in the sociology of affirmative action and race-based selection. We put a faculty member in our committee, the director of our undergraduate admissions office. We made the deliberate decision, even though there is legal risk in making this decision, not to include graduate admissions. We don't have at the University of Delaware any professional schools with the ridiculous degree of selectivity of a law school or a medical school. We have PhD and master's level programs, and we decided that those programs are operated in such a decentralized fashion that we just didn't have time to do that in 2.5 months. Our admissions process, like the admissions processes you saw described at the University of Michigan and the University of Texas, is a centralized process using a centralized set of standards. We focused on that first. We set as our goal, and we're not going to make it, the completion of our review by the review of the first file at roughly Thanksgiving time of 2013. We began by looking at the mechanics of our admissions process, which took 2 long meetings to understand. It involves forms and matrices and indices and all sorts of things. We did that review for 2 purposes. Number one, just to establish a baseline, so we knew, all of us, how the admissions office functioned. And number 2, to reinforce our belief that the program that we had complied in every respect with Grutter. And I'm pleased to say, and I certainly wouldn't say so in public if it were any different, our program totally complies with Grutter. It serves the interest of diversity, and it's narrowly tailored to include all the do's and don'ts that we're required to include. So we started by really drilling down on how our admissions process works. We then developed a list of race-neutral alternatives. We didn't identify every conceivable race-neutral alternative. We're not required in that paragraph that you saw from Justice Kennedy to consider every conceivable race-neutral alternative. I know in my darkest hours that the one we didn't consider is the one that a reviewing court will say we should have. But we looked at, probably a dozen race-neutral alternatives, using as our point of departure, not the end point, but our point of departure, a list of race-neutral alternatives that the George W. Bush Education Department had generated in 2003. They generated that list a couple of months before the Grutter decision came down, and it was a moment when higher education lawyers and other commentators were worried that Grutter would signal the end of race-based affirmative action entirely. And the Education Department's Office for Civil Rights put out a list of race-neutral alternatives. You'll see some of them further along in the outline. So we started there, and we added to that a literature search that began with friend of the court briefs that were submitted in Grutter and in Fisher, and then other works of sociology that people wanted us to consider. With respect to every race-neutral alternative, we considered them, that's the word Justice Kennedy gave us, by having a group meeting and looking at analysis to determine whether it sufficed to achieve our diversity goal without having to rely explicitly on race. And let me tell you what the important, obvious threshold question was. How do we decide how much diversity is sufficient? We made a judgment here, which I think is an onerous one for us to have made. We could have made a different judgment. And that was, we started with the class that was admitted in the 2012-2013 cycle. It was a very diverse class. It was probably our most diverse class in recent history. And it consisted of a quarter, 25% of the class was underrepresented minority. And we made the judgment that we would categorize a race-neutral alternative as insufficient if it didn't get substantially, Justice Kennedy can use adverbs, so can I, if it didn't get substantially close to that goal of 25%. And that was just an assumption we made because we had 2.5 months to do this. It may or may not be the assumption you make. But I will say that as we began this process, no issue confounded us more than trying to figure out how to gauge sufficiency. We know that if we substitute a race-neutral alternative like zip code, just to pick one, we'll get some diversity. Is it sufficient, a sufficient level or not? How do you do that without using language that sounds like quota language? Tough issue, and that was an issue that we faced at the outset. We also made the decision that in demonstrating, was that the word? In determining whether a particular race-neutral alternative did or did not suffice, we would use a sliding scale of evidence. There were some that we thought were easy to dispose of. I mentioned in the outline the hypothetical Delaware 10% plan, which would get us no diversity at all because our high school population is different from the high school population in Texas. It takes no sophistication to realize that the 10% plan wouldn't work for us. There are other race-neutral alternatives that required a more sophisticated level of analysis. And for those, the file in the cardboard box is thicker. We ran some regression analyses. We looked at the classes that was admitted in 2012, 2013. We took a sample, a statistically significant sample. We experimented with non-race, race-neutral alternatives to see what kind of minority yield it would have. We ran some numbers. I must say I didn't understand any of it, but it strikes me as compelling evidence. It's evidence that we would get up and say to a court, satisfies our burden of analyzing the alternative to see if it was workable and all the other adjectives. We haven't finished the analysis. In the paragraph 4 on page 16, you'll see the either-or question that we've teed up for ourselves. Either we will determine that we can reach a sufficient level of diversity without relying overtly on race, or we will determine, parroting the language in Justice Kennedy's opinion, that we made a serious good faith effort and there were no available workable race-neutral alternatives that would suffice. We'll be there a month from now. We have not decided whether we're going to prepare a written report. In my own mind, I see no purpose in preparing a written report that summarizes our findings. I'd rather have a big box of evidence, but we'll see whether I prevail on that. So we're doing the best we can, considering that we've had barely 3 months to design and undertake this exercise. The purpose of the exercise, again, is to have evidence demonstrating that we did a thoughtful job of conducting this analysis. At some point, I am sure if it's not our university, it will be one of your universities, will find itself in court with a reviewing court looking at the evidence generated and determining whether the institution has satisfied its burden of making this new showing under narrow tailoring. And again, I have a political bias, obviously. I don't want to assume that it's the same as yours. But I will say that in modern America, 3/4 of the judges who will hear these cases were appointed by the Bush administration and the Reagan administration. I'm not sanguine that a reviewing court, much less the Supreme Court, will give us any kind of deference in analyzing the decisions that we made. Very quickly, in part 5 of the outline, you will see a quick typology of race-neutral alternatives. And I think this outline alludes to maybe 5 of the scores of race-neutral alternatives that are available for the picking. But the Education Department, in its 2003 treatise on this subject, divided race-neutral alternatives into 2 categories: so-called admissions approaches that look on ways of slicing and dicing the admissions pool, and so-called developmental approaches that are designed to enrich the pipeline, increase the number of qualified minority students. And you'll see under socioeconomic factors on page 17, a checklist of some of the things that some universities are looking at, things like first-generation college, level of educational attainment on the part of parents, level of family income, family structure, which is one that I put a question mark next to. I'm not sure what the variables are for determining family structure issues. Single parent household, I guess, is the simplest form of that. With respect to each of those so-called race-neutral alternatives, we could spend hours, we could probably spend an entire semester looking at the literature on whether these race-neutral alternatives, either separately or in combination, suffice, whatever you read into that word. I have convinced myself, and I'm not speaking now for the members of our committee, that none of these so-called race-neutral alternatives get you anywhere near the level of diversity that you have committed to if you are committed to educating students in a diverse environment. There was a spectacular study done by a member of the faculty at the Harvard Graduate School of Education, in which he said that if you were going to target students for admission using a race-neutral alternative with the goal of admitting a class, the racial diversity of which satisfies your goals, you'd have to admit 6 times more students than you would admit simply by using race overtly. You're completely changing the admissions paradigm by using these, not to mention the fact that you're requiring information to be gathered on applications that you may not be gathering now as part of your application forms for 2012-2013. The developmental approaches are also laudable efforts. I'm not sure if they satisfy the non-hypocritical element, but they're certainly laudable as a way of enriching the minority pool, and you'll see many of them described here. At the risk of painting with too broad a brush, I will say that many of the outreach and mentoring and pipeline programs that were described by the Bush administration in 2003 are humongously expensive. Humongously expensive. If you're going to enrich your financial aid package in an effort to increase the yield of admitted minority students, for a school like the University of Delaware, where we're fiercely competing with many other schools for the minority students who do get admitted, you're talking about a financial aid investment that just is completely unaffordable for a school of our means. To page 19, and a very quick description or discussion of the Chouette decision. Michigan amended its constitution some years ago to add a provision that you see quoted there on the indented paragraph at the bottom of page 19 that prohibits public institutions of higher education from adopting race-conscious affirmative action admissions programs. And Michigan public universities are laboring now under the handicap of having to operate admissions programs that use only race-neutral alternatives and can't rely explicitly on race. A group of affirmative action proponents filed a lawsuit not based on strict scrutiny or the law of affirmative action. It has nothing to do with that line of Supreme Court cases. Rather, it's based on a principle of equal protection to the effect that you cannot take away from voters the authority to consider a perfectly lawful remedy, such as the use of race. Again, I'm going to repeat this ad nauseum. It is perfectly lawful, other than in states that have prohibited it by referendum, to take race into account in making admission decisions. The question is whether, if you allow decisions to be made on any other basis, but don't allow them to be based on the lawful consideration of race, you're violating the equal protection rights of people who want race to be considered in the admissions process. So it's kind of an esoteric legal theory. But the reason it's important is because of its practical significance. If the Supreme Court in Chouette were to say there is no equal protection violation, a state is free by statute or by constitutional amendment or by referendum to make it unlawful to rely on race, you're inviting states to do that, and you are slowly, state by state, eliminating as a practical matter the ability of at least public institutions of higher education to make decisions taking race into account. So you open up to the political process on a state-by-state basis, campaigning for the elimination of race through referendum or the enactment of legislation. So the incremental attack on affirmative action would receive a big boost if the Supreme Court in Chouette were to say that Michigan was acting lawfully by adopting the constitutional amendment that it adopted. It becomes too political for me to predict what the court will do, but if you look at the split of the court in Fisher just a few months ago, it's really hard to see 5 votes there. You'd have to have 4 votes because, again, Justice Kagan has recused herself. You'd have to have 4 votes to declare an equal protection violation, and it's hard to see where 4 justices on the court will side with affirmative action proponents in Chouette. The case is going to be argued tomorrow. There were stories in today's New York Times and today's Chronicle of Higher Education on Chouette, and there'll be more coverage as the week continues. So bottom line, which I said at the beginning of my talk, the news from Fisher is not good, It's not bad. You decide whether the glass is half empty or half full. It requires all of us to do some work if we want to continue to use race as a factor in making admission decisions. We will know in 3 or 4 years how many of the balloons in the margin on page 11 are actually interpreted by courts as stop signs rather than caution signs, as we continue to try to foster diversity through the use of race as an admission criterion. I've left 6 minutes for anybody's questions. I will pose this question to you folks. I may not be the only institution in the United States that's going through the exercise of reacting to Fisher. If any of you are parts of institutional efforts to do some of the analysis required by Justice Kennedy's opinion in Fisher, I'd love to hear what you're doing, how rigorous it is, what your timeline is, and so forth. And if anybody has comments, please let us know. Otherwise, please pose your questions. Yeah, I see it. Forgive me if my grammar was wrong. What I'm trying to say is we think 25% is achievable because we achieved that this year. We will not consider any race-neutral alternative to suffice if it doesn't get us substantially close to 25%. That's what I mean.
And then the second question is, what about discussions about who counts as an underrepresented minority? For example, looking at, say, disaggregating the Asian American category to
Right. Absolutely. And there are also, I think, provocative questions concerning the use of people who identify themselves as being members of multiple races or don't identify themselves at all. The 2-year version of this exercise would address all these questions. Right now, all I want is evidence in a box. Yeah. Yes, ma'am.
You mentioned earlier that you didn't include graduate and professional
Right.
admissions. What would you recommend?
The question was, we decided early on that we just didn't have the time or the stamina to look at the over 100 separate graduate admission programs we have. And what's our plan for doing that? I think the biggest legal vulnerability for 35 years in affirmative action has been professional schools and selective undergraduate schools. We are blessed with having no professional schools. We're going to focus on the inviting target. And then as time permits, we'll probably do 15 graduate programs a year for the next 6 or 7 years, hoping that we're not picking. Yeah. One of the reasons why graduate programs are so complicated is that the notion of an underrepresented minority varies from graduate program to graduate program. We have some graduate programs that are majority minority. We have no trouble at all recruiting a rich, diverse applicant pool in those fields. There are other fields like STEM fields where we have a deuce of a time trying to get qualified underrepresented minorities to apply. So I think probably what we'll do is we will start with the ones that are most vulnerable, where the prospect of an Abigail Fisher being generated by an admissions decision is most pronounced. We'll do some triage. If you are at institutions that have law schools, medical schools, or business schools or other professional programs, they are very inviting targets. If you look at Abigail Fisher, I'm sorry, not Abigail Fisher, Gruder. What was Gruder's first name? Amy? I can't remember what her first. If you look at Barbara, thank you. If you look at her application file at the University of Michigan Law School, which is one of the most selective in the country, she had LSAT scores and a grade point average at the bottom of the non-minority field, but that would have put her way at the top of the minority field. And she was just such a logical plaintiff. And I think, and I'm speaking just very pragmatically here, but I think I would look at our admissions programs trying to identify the fields where there would be a logical plaintiff and try to triage that way. But if you do, I started to say, if you do have highly selective professional programs or graduate programs, they should be on your list. Yes?
Why did you choose the 25%?
Because I wish I could say there was a really fancy reason, but because it's where we were, it was the best we'd ever done, and we didn't want to go backwards.
So, were you looking at the population of the state?
We were looking at the result of the 2012-2013 applicant pool admission process. And we were very satisfied. The 25% underrepresented groups, which is way higher than Delaware's population as a whole, was the best we'd ever done by quite a bit. And we didn't want to go backwards. In doing this exercise, you're sending a message to internal constituents that you're committed to affirmative action. And that's an important message to send. And so we didn't want to go backwards.
I'm just going to go a little forward. So, the whole sufficient, how do you prove that? 25%? I mean, what's your plan? What's your plan of action as a lawyer if someone like Abigail Fisher goes ahead and files?
Well, what's our plan of attack? If we to avoid being challenged on the basis of some of these subjective judgments we're making, our plan of attack is every year to learn a little bit more as courts begin to refine some of the unanswered questions from Grutter. We also hope to avert any activity in Delaware that could result in the enactment of a legislative or constitutional change that would make the whole exercise moot, although we are obviously not allowed to lobby. But our plan going forward is to every year pay attention to what's happening in the case law, try to refine our analysis. If there is an answer, embed that answer into what we're doing. We will, the pain of Fisher is in the fact that we are now part of an organic process going forward of paying very close attention to what the lower courts are doing on all these questions.
So when you say that there will be schools that basically will be a chilling factor, there will be schools that...
Well, there was a story in the Chronicle of Higher Education this morning saying that admissions offices are kind of, I don't want to oversimplify the story, but they're kind of getting ready for the inevitability of having to use race-neutral alternatives. And I think there will be at NACAC meetings and meetings of other admissions groups a more refined and more sophisticated analysis of race-neutral alternatives. It's sort of like, forgive this horrible analogy, but it's sort of like cancer drugs. One might not work, but three in combination might get you somewhere. So I think the admissions community recognizes that whether now or 10 years from now, we're going to be at a point where we can't do it anymore. Whether in your state now or in your state next year, you're not going to be able to do it anymore. So we need to come up with a framework. In a way, I'm annoyed that we wasted 10 years after Grutter. Yes?
I just wondered if you knew with this upcoming election how many other states might be considering, and then like Michigan or this one in California, other states moving politically in that direction?
I don't know. You know, I try not to spend my time monitoring the groups of affirmative action foes, so I really don't know. Does anybody know? Yes?
I'm actually doing an article about it in our higher ed journal here at the University of Vermont, and there's about 6 states that are doing it, including Michigan, California, Texas, and 3 others, primarily in the South, if I remember correctly.
We're past our time, so I'm going to thank you for attending, and I'll be happy to stay up here and answer other questions if you have them. I really appreciate your attendance. Thanks.